Hi everyone, it's attorney Rachel Kelley here. I'm finally back with Family Law Friday. Thank you all so much for tolerating my absence. I am so excited to be able to be back and to continue to share with you tips and tricks and educate people about family law because it is one of my favorite things to talk about. So today I'm going to answer the question of, does it matter what a court would do? I know this is kind of a weird question, but it's something that I get a lot, okay? I get asked all the time. Well, here's the problem, right? Describe the problem. What would a judge do? And what I find quite a bit is that the problem that gets described to me is the type of thing that I have to break to people. Listen, a judge isn't going to do anything about this. And by that I mean a judge does not want to babysit your co-parenting relationship with your ex. A judge does not want to have to make a ruling about your kids' haircuts, about the timing of your medical appointments, about whether your kids are allowed to have cell phones, about whether your kids are gonna go to this summer camp or that summer camp, about certain kinds of things like that. Whether the other parent's ex is going to be allowed to be present at medical appointments, or whether the other parents, whether stepmom is going to be allowed to be present at medical appointments for the kids, things like that. That's the kind of stuff that courts really just do not want to babysit. Now, of course, this is like a huge challenge, right? Because if you and your ex can't agree, of course, it's the job of the court to make agreements or to give you the guidance as to what your agreements need to be. But so many times when I see attorneys bringing these motions, or if I bring this motion on an issue that I think is important because it does need to be resolved for the parties, I very often still will get courts saying, well, I'm not settling that. I'm not going to resolve that for you. I refuse. And, the reason, of course, is that the courts really want people to figure out how to work things out on their own because they just can't be there to babysit you. They do not have the capacity for that. And so ultimately, they don't want to create situations that permit another party to try too much to control and overreach as it relates to the things that happen on the other person's parenting time. And also, they don't want to give you guys more opportunities to be going back to court to fight about more stuff, right? So if you have a situation like that, where you are constantly thinking, well, what would a judge say? Well, what should I be doing? What should I be doing about this? Where a lot of these things are related to not major decisions, but day-to-day issues. The first thing you need to do is go read Joint Custody with a Jerk, because it is, in my view, the best book that helps you walk through whether you're being unreasonable or whether the person you're working with is unreasonable. And then it gives you really good guidance about how to deal with that. But then the next thing you probably need to do is start thinking, okay, if this is how this is and this is how it's going to be, do we need to consider a change in custody? And if that's where you are, it's very important that you seek some advice from an attorney in your area to talk about these issues to determine whether they think that it's a good time and that you have enough instances and enough evidence to seek a change in custody, whether that's a change in legal custody or physical custody. Next week, I'm going to talk more about legal custody and when it's a good time to ask a court for sole legal custody. Well, thanks so much. If you have any questions, and if you're at that point where you're considering whether sole custody is important for you, please give our office a call. We're here to help.